Well, hello and welcome. This is the webinar on 2019 Brexit implications. We have put on our crystal ball and are trying to look forward on what's going to happen between now and May of 2019 and what Brexit means to U.S. companies, especially U.S. companies with UK subsidiaries. My name is Ed Hannon. I'm the moderator of the panel today. I'm a partner at Quarles Brady and chair of the Chicago Business Law Practice. We have a great panel today that I'll introduce. We have Aidan Byrne from RSM Ireland. We have Nicole Basher from Quarles Brady Intellectual Property Group. And we have Matt Dollar, Director of International Client Service and the Ireland Country Desk. Before we allow each of our panelists to introduce themselves, just a few housekeeping items. We will be applying for 1.5 hours of continuing legal education credit. If you are with us live, we have a sign-in sheet for you to get that. If you are viewing on webinar and would like CLE credit, please complete the CLE form located at the back of the PDF copy of the materials and return the completed form to the contact listed there. A few final items for webinar participants. We have muted all of the phone lines for you dialing in and participants listening via audio on your computer, so you will not be able to speak. If you would like to submit a question, please type it in the Q&A box located in the upper right corner of the dashboard, and our conference host will make sure that the speakers will receive the questions and they will be brought up to us to talk through towards the end. So please feel to submit questions. And with that, we have a great panel today, hopefully somewhat of a global perspective. And the goal today is to obtain a business perspective on what is Brexit and what does it mean to U.S. businesses, either that have UK subsidiaries, that have other subsidiaries in the EU that interact with the UK subsidiary, or you're just a business out there that's contemplating moving into the EU or moving into the UK and need to understand what Brexit can mean for you. We have Aidan Byrne, and I'll let him introduce himself in a moment. But Aidan is the lead tax partner in the Dublin office of RSM, and I think gives us a unique perspective in preparing for today. We talked through a little bit of the differences between what goes on in the United States as far as governments are formed, policies enforced, and trying to get our arms around how to explain Brexit in the EU in that context. So we imposed upon Aidan to step out of the world of tax and into the world of international diplomacy. So we appreciate your willingness to dive into there. Also, what's interesting about Ireland and the UK and the similarities, there's a common law in both UK and in Ireland. That's not true in other EU countries. That makes the analysis pretty similar. Obviously, English language is spoken in both the UK and in Ireland. And what's interesting, even if there's a hard Brexit going back to the existing treaty between Ireland and the UK, there's a free movement of people and employees between the two countries. So that could come into play regardless of how Brexit plays itself out. So, teeing up those sort of concepts and objectives, Aidan, why don't we start with you, and you can do a brief introduction, and we'll move down the panel.
Sure, thank you. First of all, thank you for inviting me to be here. I always love coming to Chicago, so it was great to have an excuse to visit you. I lead the tax practice of RSM in Ireland. My role focuses entirely on working with companies that are internationalizing and seeking to access the European Union. So whilst the advice I would give would bring many of those companies into Ireland in particular, what we would always do is analyse the fact pattern in each case to see whether or not Ireland makes it a good fit for the company. RSM are in all the European countries, so we're able to work collectively to get the best result for the client, rather than sort of, being engaged in trying to get the client to move to Ireland. In the context of Brexit, which I'll dive into in a little bit, obviously Ireland and the UK have a long history, some of it not great, but more recently the relationship between the two countries has been very, very good. The amount of trade between the two countries is really high, and Brexit is, not a good thing for either country, particularly at the moment where there's no clarity as to what Brexit actually means in a sort of a future relationship. So
I'm Nicole Basher. I am a partner and patent attorney here at Quarles Brady in Chicago. I have a background in chemical engineering and spent a number of years in the software industry before I went back to law school. My practice now is advising multinational corporations on their intellectual property strategy. So that includes both here in the U.S. and globally, including a number of businesses that operate, have significant operations in Europe. So that entails everything from, standard patent prosecution, so procuring patents to protect our clients' innovations, to enforcement and making sure that our clients' rights are properly enforced globally. And then a third of the practice is really directed toward licensing and agreements, and then due diligence in different types of M&A transactions, so reviewing target companies for potential mergers and different types of technology and things like that.
Thank you for having me here, Quarles and Brady. My name is Matt Dollard. I work in our Chicago office for RSM. I've been with the firm for about 20 years now, and the balance of my career has been in our international service office, whereby I've been working with multinational accounts almost the entire time of my career. I started as an auditor. We are an audit, tax, and consulting firm, but I like to joke that I'm a recovering auditor. I haven't done an audit in quite a while. The balance of my time now is working with multinationals, helping them expand internationally, helping them with their global compliance overseas, and helping them manage and coordinate a lot of those services throughout our firm. I also wear the Ireland country desk hat, where I'm responsible for being the U.S. liaison between our U.S. firm and our office in Dublin, Ireland. So Aidan and I have worked quite closely together over the years as we've known one another. And I'm very happy to be here and participate on the panel.
Great. Well, thank you all for joining me today. Hopefully what will be a educational discussion. But what's interesting is on behalf of all the speakers, right now we don't know what the rules are. We don't know how this is going to play out. So as we express opinions, as we pontificate and try to gaze upon the world as we see this playing out, just note that our fear in putting this together is that some deal was announced on June 7th, making this entire webinar obsolete. So between now and for those of you that are playing it back, note that we are using our judgment, our best guesses here on what happens. But not getting too far ahead of ourselves, Aidan, being the non-U.S. person on the panel, will impose upon you, understanding the EU and Brexit. From a U.S. point of view, it's difficult for us to comprehend, putting governments together, building coalitions to have a government. The concept of the EU, in my mind, is this akin to one of the United States, Connecticut saying, I don't want to be part of the United States anymore, just trying to get our arms around, we read in the news that the UK has elected to exit the European Union, thus the acronym Brexit. But can you help us sort of put it in perspective and what path do we have going forward under the EU charters?
Sure. So I suppose the European Union has developed over the last 50-odd years, and initially it started off as a common market. So simply a group of countries came together and trade was capable of being transacted between those jurisdictions without tariffs, without customs duties, etc. The European Union has developed over those years and has become, I suppose, far more than a simple trading bloc. The European Union reaches into every part of society in the context of employment legislation, in the context of certain freedoms. The key freedoms being the free movement of people, which allows anyone from within the Union to work in any other country within the Union without any visas or any permissions. And I suppose if we were to analyse why the UK made the decision it made, a lot of it would come back to that point, whereby they felt that there were too many Europeans moving to live in the UK and work in the UK. So the UK has always, for the last 40 years or so, has had a difficult relationship with the European Union. In particular, the major political party in the United Kingdom, the Conservative Party, has always had a strong Eurosceptic bunch of people in it. And I think politically, David Cameron won an election he didn't expect to win. He had been in a coalition, and all the opinion polls suggested that there was going to be a second coalition, and he made a promise that he would hold a Brexit referendum should he be returned to power. And unfortunately, he was returned to power with an overall majority, and therefore he had no excuse not to hold the referendum. The referendum itself was, I suppose, if you were to analyse the debate that went on, if I can borrow an expression that was generated over here, there was certainly a lot of fake news used in terms of giving information to the people who ended up voting on the referendum. Facts were put out as facts, and they just certainly weren't real facts. It was also quite a low turnout in terms of such a fundamental decision for people, and the margin of 1% in favour again shows how divided the country was. If you dive into the actual figures itself, what's slightly tragic is there was a massive stay vote, so remain within the European Union, for people aged 30 and under. So the people who will actually be the future really wanted to stay, whereas if you look at people, let's say, over 60, it was a large exit vote. And unfortunately, democracy being democracy, you can't force people to vote. The turnout from young people was quite low. Glastonbury was on the weekend of the vote, where you get about 500,000 people at Glastonbury, most of them being young people. And when you think of the margin was only a couple of million, it was unfortunate.
Good. So the UK formally triggered Article 50. The understanding is that it set a 2-year period to negotiate, and at the end of that 2-year period, the UK will formally exit the EU. And from the United States point of view, our government seems to be based on last-minute deals. If you could provide some color on what happens if what they need to reach that deal or an extension.
So again, every law that's passed within the United Kingdom since they joined in 1972 has had the requirement to be compliant with European Union law. The final arbiter of law within the European Union is the European Court of Justice, the ECJ, and part of the Brexit negotiations lie around how future disputes between the UK and the European Union will be adjudicated on. The UK have said that they will not submit to the authority of the ECJ, so therefore that leads to a whole lot of questions around current, say contracts, employment rights. All of those rights currently could end up in the ECJ, but post-Brexit, because they won't submit to that authority, because they want to, regain their courts having the final say, that is a major issue. In terms of trade itself, currently the United Kingdom is part of the European trading bloc, so it would be similar to, somebody in California selling to someone in New Jersey. It just happens, borderless trade. Post-Brexit, the UK will become a third country. When it becomes a third country, it then needs to have a new relationship with the European Union. That typically will be some sort of a trade deal, which on the face of it should be easily negotiated. But the last trade deal the European Union completed was with Canada, CETA, which took 7 years to negotiate, and they were two willing parties. Here we have a messy divorce going on. So getting a deal done by 2019 is very, very unlikely. And I suppose just finally, the last point is the EU can't allow the UK to have as good as or better position post-Brexit, because that would totally undermine the whole philosophy of the European Union. So there are hard negotiations ahead, and I would be very surprised if they're agreed by the date of March 19th.
And that March 19th date, to extend it, as I understand it, would require the unanimous consent of the EU countries. Is that correct?
Correct. The European Union has a lot of protections built in for smaller countries. So it's not like, Germany being the biggest country has the biggest number of votes. Every country has a vote. And in terms of Article 50, and in terms of giving an extension to the transition period, each country has the ability to vote it down.
Interesting. Okay, that's great. So just getting you back to where are we now? I think you've covered most of these, but it sounds like at the end of the day they need to at least have a framework or something substantially done before the end of April of next year.
Correct. I don't think they'll have a deal done, but it would be good to understand what the UK really wants in terms of a future relationship. They have made, that quote there, a bold and creative agreement on services. I mean, they're very easy words to say, but what does it actually mean? What they're looking for, what they've said is, from a regulatory perspective, they will maintain what they call equivalence. So in other words, nothing will change. However, they've also retained the right to change if they want. So it's very hard to understand how you would do a deal based on the current relationship if the other side is capable of changing its mind for whatever reason. Boris Johnson, who is the Foreign Secretary, has said he would like the UK to become the Singapore of Europe. So, that would mean that they would be potentially doing deals with third countries like the United States, which would be better than the deal the EU currently has with the United States. So they would be undercutting the European Union. So that obviously would feed into what type of a relationship the EU is going to have with the UK.
Okay. So back in March, we got a sign of hope going down that path. There was a transition agreement. The UK conceded the EU citizens' rights and on fishery policies. They want to be able to negotiate and try their own trade deals during the transition period, and that during this transition period that the UK will remain a party to existing EU trade agreements but will not have voting rights. Now, as I understand it, again, this has not been ratified to date by the whole EU, and it sounds like there's still this drifting of where the negotiations are going.
Yeah, so Michel Barnier, who's the lead negotiator, is representing the European Union. I think if he gets a deal that the wider EU will sign up to, it's probably unlikely that a country will, suddenly go rogue and vote it down. It's not in the European Union's interests not to have a proper relationship with the UK. So the European bloc wants a proper trading relationship because both parties will suffer very badly if a deal isn't done. But again, I think it's getting the UK to understand that they can't have their cake and eat it. There is going to be a cost to this. So initially, they said they wouldn't pay an exit charge. It's now been agreed. It's quite a substantial figure. They said that the questions of the rights of citizens who are already in the UK and vice versa. Again, a deal has been done on that in terms of transitioning from being a part of the EU to being outside of the EU. The Irish border is constantly coming up as a major sticking point. And just to put some context on that, the island of Ireland is divided in two. The Republic of Ireland is an independent country, and then in Northern Ireland is part of the United Kingdom. And therefore you've got a bit of the United Kingdom on the island of Ireland. And that is the only border with the European Union. That's not a sea border. So up until the late 90s, people were aware the Irish Troubles, as they were called, effectively civil war was going on in that part of the world. The Good Friday Agreement brought that to an end, and we now have a scenario where you literally don't know when you're leaving Republic of Ireland and going into the UK, other than the speed signs change from kilometres to miles per hour. But literally, it's frictionless and non-existent.
And that open border was one of the linchpins of the Easter Accords that really ended the troubles and allowed for a free movement of goods and people back and forth. And as you noted, it's a invisible border.
Correct.
Where people will commute back and forth. There's goods going from there. So, just to get your perspective, it sounds like the ability to reach a deal is somewhat solving this border issue, because if a hard border goes in, that's not what was contemplated in the Easter Accords, and really not where the economy of Ireland and Northern Ireland has gotten to, and appears to be very disruptive if they were to put the fences and guard posts and everything's back up like it was pre-Easter Accords.
Yeah, I think the fear is that those physical signs of separation will lead to a re-engaging by the I suppose I'd call them criminal elements, to get that struggle restarted. Many people live in Northern Ireland and work in the Republic of Ireland, and vice versa. So the existence of a border, we all know it's there, but in a very Irish way, it's not there in real terms. So going back to those days, I think, would be very counterproductive.
And I think from a U.S. perspective, that's difficult to get our head around. That Brexit could come down to, are they putting in a hard border between Northern Ireland and the Republic of Ireland? But from an EU perspective, it's a very real issue, I believe, just because of the politics of EU and some of the other countries, is my understanding, have expressed support for backing Ireland in connection with this discussion.
Yeah, I suppose recently the EU Commission issued a statement. When it comes to the border, we're all Irish. So I suppose as an Irish person, I'm surprised by the strength of support over the issue. But I think it goes fundamentally to another point, and that is the British signed a deal on the Irish border about 3.5, 4 months ago, and they're already trying to move away from that. So I suppose that puts into question, when is a deal done with the UK if they flip-flop so quickly afterwards?
Sure.
And I think that comes to the big problem about this whole issue, comes to the rift that exists within the Conservative Party, the government party in the United Kingdom, whereby you've got more Remain MPs than you have Leave MPs. So the UK Parliament, if it was to take a free vote, would vote to stay within the European Union. But the people have spoken, and the British government feels that it has to deliver on the Brexit decision.
And what's interesting is, Theresa May's government, part of that coalition is made up of the representatives from Northern Ireland. So that really, appears to make this whole discussion wildly complex from Theresa May's ability to keep her coalition intact and not have the need to form a new government.
Correct. The decision on the backstop position for the border was taken without the imprimatur of the DUP, who are propping up her government. So I suppose politically it perhaps wasn't very sensible for her to sign up to something without having the people who are keeping her in power on board.
Interesting. So I think the takeaway from this discussion on what is Brexit and what does it mean, it's not as simple as negotiating a trade deal. There are a lot of dynamics. It sounds like the UK can't quite articulate objectively what they're looking for. The EU, obviously, from a policy point of view, wants to make sure that they don't allow the UK to have a better deal than existing members of the EU. And then we have the seems to be the ongoing specter of Ireland and Northern Ireland, and the hope that the progress made from the Easter Accords doesn't get undone by Brexit.
I think that's a very good summary.
I think it's also a couple other things to point out is I don't think any side is looking for a hard border between Ireland and Northern Ireland. I think all parties are in agreement to that. The crux, as Aidan pointed out, is if you've got a trade agreement that gets put in place or tariffs that get put in place, how could you have an open border? So that is definitely the rub. The other thing to probably point out is to where we are today is all the things that just are still yet to be done. This started almost 2 years ago, and we are really not any closer to having an agreement on either side that's acceptable to all parties that are allowing people to move forward. So the pace that this is moving is begrudgingly slow for the reasons that have already been pointed out. So it's difficult and it's uncertain, even as we sit here today, to understand where they move forward from here. And if you're following the news, there was just another proposal put forth yesterday by Theresa May's government on trying to address the backstop issue, which I think the EU is already questioning whether or not that's going to proceed forward. And this is, I don't know how many proposals they've made now. I think this is proposal number 3 or 4 now.
There was 2 this week.
2? Okay,
so
proposing.
Earlier in the week, there was a proposal that there would be a 14-kilometre zone along the Irish border, which would remain within the European Union for trade purposes for a transition period. But that got rid of very quick. Yeah, so the latest one is that they'll remain within the customs union till 2021, the whole of the UK.
Right.
The difficulty with that is if you stay within the customs union, you have to allow the free movement of people, goods, capital, etc., the 4 principles on which the European Union is founded. Yeah. And the UK government have said they don't want the free movement of people. So I'm not sure how they would make it work. From an Irish perspective, 2021 is not that far away. So having a deal done by then is probably unlikely. Again, back to CETA, two willing parties, it took 7 years, because trade deals are very difficult to negotiate. The other thing is, there is nobody within the UK who has negotiated a trade deal since 1972, when they joined the European Union, because all the deals are done centrally within Brussels. So the actual skill set to get these deals done, I'd be skeptical as to their ability to deliver on it.
Well, it's interesting. It sounds like there's a lot of unintended consequences that need to be thought through just because this is such a complex situation. So, just skipping ahead, again, the complexity of Brexit, it's difficult to get your arms around. But Aidan, you put together this timeline, and quite frankly, we have April 2019. Britain to formally exit the EU. That seems to be very close, but there's a lot going on in this timeline. You want to take a few minutes and sort of walk us through some of the other items that may once again make this negotiation even more complex or unpredictable?
Yeah, I suppose that where we're at the moment is sort of we just had the Italian general election, which didn't prove conclusive. So I think we're probably going to be having another Italian general election. And I suppose what's interesting about that result is a populist party, two populist parties who would be pretty Eurosceptic, so would be, not dissimilar to the Brexit people within the Tory party, received a huge popular vote. Again, I think if you scratch beneath the surface, there's a lot of economies that are still, haven't finally come out of the economic recession, and politicians are taking advantage of that by promising, we'll change the world, and the reality is that it's actually very difficult to change the world, and it becomes more difficult to change it if you're not working in concert with your trading partners. So I think political events within Europe are complicating the negotiation process. So it's not all the UK's fault. I think it would be much easier if we really knew what the UK wanted, because I think that's the starting point. It's not that they'll necessarily get that, and even Theresa May has accepted that she's not going to get everything she wants, but at least if you knew where they wanted to start, you could get into negotiation. On the European side, though, the Spanish general election will be happening, and again, Spain is going through a lot of trauma at the moment. We've got the party out of what part of the country?
Catalonia.
Yeah, Catalonia. Thank you. So the separatists, with the majority there, looking to bring that region out of Spain. So there's an awful lot politically going on within the European Union. It's not just the UK, and an awful lot of it is driven by the same type of thing, which is, I suppose, the rise of globalization, with major corporations playing such a key role in the economies of the world. On the tax side, the BEPS, so the base erosion profit shifting, the plan that was put together by the OECD and the G20 around the taxing of these large multinational companies was driven hugely by public resentment at the likes of, I won't mention any specific names, but the likes of some very large companies paying very little tax, when taxes for ordinary people were rising hugely because of the deficits that each of these countries had. So that's the narrative to the whole Brexit conversation. So I'm certainly not sitting here trying to Brit bash. Exactly the same type of issues arise in other countries, and political events may overtake us between now and the end of 2019.
Great. So now that we've scared everybody that nothing will ever get done, let's, for the rest of the discussion, I really want to sort of set the table on what should business owners be thinking about. And I think it's easier to sort of set an anchor on one side. What are the consequences if there is hard Brexit. I think we can all understand that hard Brexit is unlikely. Something will get negotiated. What that is, we don't know. But I think it's to understand if the worst case scenario happens, what does the world look like if you are a U.S. company, your only connection with the EU is through a UK subsidiary. And as we walk through these, we're going to end the discussion with what planning opportunities should you at least be considering as the next 12 months evolve towards this May 2019 date, and what things at least you should be considering. So let's sort of move into the next phase of the discussion. Consequences for a UK subsidiary if there is hard Brexit. That is, as Aidan said, the UK becomes a third country, not part of the EU, does not enjoy all the benefits of an EU member, and what are those? And just a couple bullet points on the slide. The access to the EU directives. There will be withholding taxes to the extent that there are payments between the UK and the EU. There is a value-added tax that would be imposed on the goods shipped into the EU by the UK subsidiary, possibly WTO tariffs imposed, delivery delays in hard goods because of border control and customs enforcement, currency management. The UK is going to go back on the sterling, or has go back on the sterling. That will be its functional currency, not the euro. So the extent that they are doing business in the EU or with EU trading partners. And then, regulatory uncertainty. And Nicole, I'll know you're going to jump in on this. GDPR just came into effect recently. Big European Union push on data privacy. The penalties of running afoul of GDPR, as have been explained to me, are tremendous. The question is, post-Brexit, how do you manage that from a U.S. perspective, where you have the EU with one interpretation of GDPR and the UK courts with possibly a second interpretation? So again, somewhat complexity. Again, data exporting between the UK and the EU. How is that going to work? What regulations are going to apply? And then the free movement of employees. Many of the clients that I deal with will have employees, independent contractors that are working out of their home in France, in Germany, in Spain. Many of the companies I deal with do have UK subsidiaries. It's very easy right now. It's this akin to, I'm headquartered in Illinois. I have employees in Texas and Connecticut and Florida working out of their homes. That whole changes with Brexit. So a lot of, again, the benefits of the EU, reducing those economic borders, all of those come crashing down if there's a hard Brexit.
Yeah. And then if I could just maybe comment, I was looking at a couple studies that had been recently published around the financial impact just around the tariffs if we were looking at a World Trade Organization type relationship where the UK would have that with the European Union. And they had calculated for the European Union, they would be increasing, and this is just with tariffs and taxes, $31 billion annually. For the UK, those costs would be $27 billion. Now, in a non-World Trade Center arrangement where maybe they've got some beneficial agreements, both of those costs would be about halved. But I think the point here is costs just to deal with that extra compliance in a third country are going to be borne on by both parties, both at the border and even before the border. And if you're a smaller company that hasn't had much experience trading outside the European Union, for example, you may not even have the skill set in-house to, like, how do we operationally trade outside of a large trading block that we're comfortable with. Bigger companies, as many of us maybe pointed out, will maybe have already dealt with some of this, but there is a large swath of companies that have yet to really contend with the issue.
Absolutely. So, then the question becomes, From a taxation point of view, there are existing tax treaties that the UK has in place. So I imagine, and again, we don't know, even if a deal is done, what's going to happen to taxation, but you would think that the treaties would come back in. So Aidan, again, you have a subsidiary in the UK. You're continuing your trading relationships with members of France and Spain and Germany. From a tax cost point of view to that UK subsidiary, what does that mean?
So currently, if you have a group of companies in different jurisdictions within the European Union, the payments between those companies of interest or royalties or dividends can be made without any withholding taxes. Once the UK leaves, whether it's a hard Brexit or a soft Brexit, those directives won't be available, which means that payments will be subjected to withholding taxes, and those withholding taxes will be based on the treaties, the tax treaties which exist between, say, the likes of UK and Netherlands, UK and Germany. The difficulty, I suppose, is some of those treaties are quite old, and the older treaties tended to have the higher withholding tax rates. So companies need to be cognizant of what their intergroup structure is and plan, and they can plan ahead. This is something that can be done now. They can look at their structure, what payments happen between what jurisdictions, and change it, because some countries have universal relief, say the likes of Ireland. Even though, say, between Ireland and the US there would be withholding taxes per the treaty, Ireland unilaterally waives it, so payments can go out to the US without any withholding taxes. So if companies look at their structure now, they can potentially get in place a structure that will work post-Brexit. Because I suppose I'm a little bit suspicious that as we get closer to the final deal, governments will likely look at how can we stop a flight of capital. So they could bring in anti-avoidance legislation to stop companies actually physically moving. So that type of planning can be done now. And I suppose I've had many requests to set up Irish subsidiaries of companies where they intend putting nothing in Ireland. So what they'll have is a paper structure. Yeah, they'll have a paper structure that on the face of it works, but there's no substance to it. And because there's no substance to it, it won't actually work in real terms.
Yeah, and we're going to revisit some of the strategies,
yeah.
but just want to, again, setting the table, you elect to take a wait-and-see approach. You do no affirmative planning. What are the problems that you're going to face? Again, we're putting in the context of hard Brexit, but even if a deal is done, as you said, they're not going to get a better deal than the existing European Union. So it's important to identify, okay, now we have more taxes, supply chain. I think we've alluded to many of these.
Sure. So, supply chain, again, is a very easy one to deal with in that you just need to do an analysis of your business. Where are your customers? Where are your goods coming from? And if you're manufacturing, where are the various pieces that go into whatever the manufactured good, where do they come from? And look to review that supply chain to make sure that insofar as it's possible, you're either in the UK or you're in the EU. But
not going back and forth.
Yeah, so there's a classic example of there's a huge amount of milk brought from Northern Ireland into Southern Ireland where it's turned into cheese. It then goes to the UK where it's put into pre-finished food which is exported to the United States. It's one of Ireland's largest companies. Now, up to now, the only piece that required customs clearance is when it hits here. When Brexit happens, it'll be going from the UK to Ireland to the UK. So there will be potentially two additional customs clearance requirements. So I suppose what that company is already doing is it's looking at its supply chain and probably going to source an awful lot of the product in Ireland and take the UK out of the equation. But the opposite could equally be done, But again, what they've done is they've looked at, the cheese product that ends up in the States. How are the bits of that made, and where did it come from? So it's very practical steps that companies can take now, regardless of what the outcome is going to be. The UK is going to be a third country, so you can plan for it now by just simply analysing your business.
And then just sort of to finish up the regulatory environment, again, with the UK becoming a third country, it's two different standards, two different regulatory standards. No one with it, can understand where they'll diverge.
Yeah. So again, I suppose every product that's manufactured within the European Union has regulatory control which vests effectively in the ECJ. Post Brexit, the UK will leave the control of the ECJ behind it, and therefore any product which either comes from the UK into the EU or vice versa will have to go through some sort of new procedure. The UK have said what they will continue to do is maintain equivalence. So in other words, they will keep the same standards and they will mirror exactly the current standards. However, they've also said that they will retain the right to diverge if it suits them. And I suppose that may be simply being said to show that the ECJ is no longer going to maintain its control.
You still got to get your product into Europe.
You still got
to adhere to European rules.
So I suppose that currently, if you're in the UK, your product is passported into every other jurisdiction within the European Union. So if you get approved in one country, the other 27 automatically recognise it. Post-Brexit, that won't be the case. And potentially the UK and companies that are in the UK supplying into the European Union will have to go through a second approval procedure. And I think there could be huge cost implications for companies.
That's an excellent point. I would note that the UK, within our own client base, is the number one location for all of our internationally active accounts. That's if they expand overseas, into Europe, it's the UK. So we already have an enormous foothold of accounts that are already there. And I absolutely agree. The analysis of the supply chains and where that's coming from. The other issue is critically important. The other issue is rules of origin. If those start coming into effect, what's that going to look like? How much content have you got that's non-EU versus EU? And that's something that would have to be dealt with as well. And that's not, we deal with that here in the U.S. with auto manufacturing and the like. So it's that would be another thing they'd have to contend with.
Now, we've gone from the tangible goods. Let's sort of add some complexity, and Nicole, get into your world, intellectual property. So you're a UK subsidiary of a US company. You've previously acted as the gateway into the EU. Now Brexit comes. What are the list of things in your checklist that you need to talk through with your clients?
Right. So, to sort of set the stage, as you mentioned, intangible goods often becomes a little bit harder to discuss just by its nature, but you would essentially break down IP into a couple of different major categories. And, consistent with this discussion, none of them really fit with each other seamlessly. So you have regular patents really covering the functional aspects of how a product or process works. You have community registered designs, which are a type of patent that covers the aesthetics or the look or feel of a product. And then, of course, you have trademarks, which really is a source indicator of goods or a service. And so all three of those regimes would be kind of form the major part of your IP portfolio. And as I mentioned, they don't really fit seamlessly with each other. So, of course, there are different rules governing all of them. So To break it down, I thought it'd be useful to really look at this from a couple different aspects. So first, with respect to your existing registrations, so any existing patents that you have right now, and any existing trademarks and registered designs. So helpfully, we can start with the easiest thing probably in our whole conversation today, which are that patents in the UK post-Brexit are really unchanged, which is probably the most concrete thing we will say today. That's in part because of the current patent system right now, just the way that it has been operating in the EU as a whole. There's a system in place where you can actually file a patent application in the EU, and at the end of that process, you systematically select countries in which you'd like to have your patent active. So if you didn't select the UK previously, you won't now have the UK as a patent, and vice versa. So, from that standpoint, it's very straightforward in terms of existing patent rights, and those would be your regular utility or functional patents. Moving over to trademarks and registered designs, that's where it gets a little bit interesting and fun. So in the EU right now, there are European trademarks, so EU TMs is the kind of shorthand for that, and then registered designs. And so those really span throughout Europe as well and give you protection through all of the EU. So there's not really anything concrete yet about this, as we've been talking about, but at the end of March, there was, again, an update about where we think things stand. And so as of the end of March, there's this 2-year time frame, as we've all been talking about, for this transition period. And so the first point here is that European trademarks won't cover the UK post-Brexit. Helpfully, I suppose, at least the current discussion now is that a European trademark will automatically stem the equivalent UK trademark. There's a lot of uncertainty about that because no one seems to know how the previously sleepy UK IP office now all of a sudden becomes a huge hub of trademark filings, globally. So there's been some discussion now, in terms of a business operating in Europe and the UK specifically, potentially filing now and being proactive before this gigantic rush of new applications comes in. And again, there's a lot of operational issues there in terms of how the UK is going to handle that conversion. The idea that there's a couple of associated issues with trademarks specifically. So one of them is that you actually have to use your trademark in different jurisdictions. And so there's a continuing question about what it means if you have only used your trademark in the UK or if you've only used your trademark in other parts of the EU, and whether that will suffice for the opposite jurisdiction. So if you've only used your trademark in Germany, for example, will that be enough for you to sustain your trademark in the UK? So there's a little bit of debate. Right now, the answer seems to be trending toward yes. I think there'd be kind of an uproar otherwise, but that's at least where things stand now. But that's definitely an unresolved question that, we just don't know the answer to. So establishing use is really one of those areas that we just don't know how it'll shake out. So any businesses operating in the UK and, throughout the rest of Europe, this would be a good time to review marketing materials. Make sure you are using your trademark in the different jurisdictions if you'd like to, be sure that you continue to have protection. So switching gears a little bit into new filings, this is also fairly unchanged. And the reason for that is because there are already a number of international agreements that govern different parts of IP. So first is the Madrid Protocol, which really governs, it's an international treaty that allows you to register a trademark in all kinds of different jurisdictions through one seamless process. And so that already is in existence and is already currently being used by global national companies to great effect, actually, because it's a pretty seamless process where you're filing one single application. You're able to then select the different countries that you want protection in. The Hague Agreement, again, is another international agreement that really governs the community registered design process. And so There's one little hiccup here, which is, and again, it works very similar to the Madrid Agreement in that you file one single application and then select the countries that you would like to continue to have protection in. The wrinkle here is that the UK is currently not a member of the Hague Agreement. So that's a little bit of a snafu, but it's apparently the UK will be joining next week. So we'll see if that actually ends up coming to fruition. But in the whole scheme of controversial topics, the Hague Agreement is not usually one of them, and it really does create a pretty seamless process for a company who's trying to file new IP. Next, Patent Cooperation Treaty and European Patent Convention. The Patent Cooperation Treaty is an international agreement. There's many countries that are involved. Again, like Madrid and Hague, it's one single application and allows you to elect to file your patent applications in a number of jurisdictions. The European Patent Convention is interesting. It's more or less the process where you file a single patent application within Europe proper, and then at the end of that time period, after your patent has been allowed, you end up paying individual fees in specific countries that you want your patent to be valid in. And this has been sort of a big sticking point in the EU generally in terms of how to distribute the fees from companies who are filing these patent applications. Because for many years there's been a push for unitary patents, which the idea there would be there'd be one centralized organization and review of patents, that then your patent would be valid throughout all of Europe. This has been discussed for probably as long as I've been practicing law, so quite some time now, and is still yet to come into fruition. So we won't be holding our breath on unitary patents, at least just right this second. But in the meantime, the Madrid Protocol, the Hague Agreement, the PCT, Patent Cooperation Treaty, and European Patent Convention, all very helpfully were international agreements all in place previously. So really for new filings, the major consideration is not the mechanism you're using, but really whether you will be filing and selecting to have a patent in both the UK and maybe other parts of Europe or globally. So really taking a hard look at your current patent filing strategy and then understanding whether it's worthwhile to get a separate patent in the UK. And that may or may not change depending on the status of your company. But if you're not currently filing to get a patent in the UK, maybe there's not necessarily a reason to start now. Conversely, if you already are filing and getting protection in the UK, it would probably seem reasonable that you'd continue to file in the UK. So that covers existing and then new, forms of IP protection. The other areas where things get a little bit interesting from the enforcement standpoint. So from a patent and trademark clearance standpoint, frequently global national companies will look at the US, Europe as a whole, the EU, perhaps somewhere in Asia, China, or Japan, to gauge whether their new trademark is clear and wouldn't infringe on other companies' trademarks, and similarly with patents to make sure that their patents are clear of other people's IP as well. And so the question then becomes, from a clearance standpoint, now will we be looking at the EU and separately the UK? Understanding that the UK is such a large economical hub, it's reasonable to think that there's a significant number of patent and trademark filings there. So in essence, we think what will end up happening is it will, you'll have to increase your budget, to account for the separate UK filings, because you won't pick those up in your general EU clearance review that you're conducting originally. And similarly, if you have watch programs, which people in the IP world are frequently trying to pay attention to what their competitors are doing, again, those are normally, geographically based. So, then the decision becomes, are you going to continue to watch, EU plus the UK, or are you going to somehow narrow that down? And the final piece is the Unified Patent Court, which also is a question mark because, again, this is something that has been talked about for a very long time. And has yet to come to fruition. And I see Brexit as just another obstacle to the Unified Patent Court. Currently, if you have a European patent that's valid in a number of jurisdictions, you must file suit in the jurisdiction, that you're thinking about. You can't. There's not a centralized court system to handle that interaction. So what ends up happening is, if you are asserting a patent against a competitor, you might have to file suit against them in 3 or 4 different jurisdictions. You can't file suit in a centralized location, which really makes it inefficient and difficult to enforce your IP rights throughout Europe. So hence the Unified Patent Court really is an attempt to try to make this a little bit more seamless, make it easier for companies to enforce their IP rights. But that said, there's a lot of discussion about the mechanics of this. Right now, the latest on this, there's been some discussion that there'd be 3 courts as part of this Unified Patent Court. One would be located in London, one would be in Paris, and another would be in Germany, covering different technologies. That's essentially the only thing we know right now. There's allegedly people are being hired behind the scenes, and again, this is numerous years worth of discussion. So it's really unclear as to whether this will come to fruition, especially with all the things we've been talking about today. And the last piece really, I think, is a huge takeaway for essentially every person here today, which is any sort of existing agreement that you might have, and the specific terminology that you're using. And this really comes up from an IP agreement standpoint, essentially always, because what ends up happening is you have some sort of territory or jurisdictional aspect, and so then the question becomes, is the terminology that you're using right now, will that be consistent with post-Brexit or soft Brexit or hard Brexit or wherever we end up? And so, this is a today take-home in terms of pulling your existing agreements in all different aspects to understand, is this agreement impacted by these jurisdictional or geographical aspects of Brexit? And what do we have to do there? And, there's a couple very specific ones from the trademark and patent world. This idea of consent agreements. If you have a conflicting trademark, you might agree to coexist. You might have different licenses that are impacted. And again, field of use and territory and things like that. But, that is definitely an action item right now, because I can see a wave in the future of, a lot of disagreement and disparity about what people mean, particularly because many of these agreements were drafted pre-Brexit.
So, Nicole, I'm curious. So we've seen certain things change post-Brexit. For example, foreign direct investment into the EU is actually, we think, increased as a result of Brexit. We've seen foreign direct investment reduce in the last year and a half into the UK due to Brexit. So investors are voting with their feet due to uncertainty. Are you seeing similar activity with patent applications? Are you seeing a change in behavior where those patents are being applied for? Or is it still just too uncertain and people are sitting on the fence?
So so from the patent world, no, but from the trademark world, yes. Trademark world and registered designs, in part because until the end of March, when this most recent directive was put forth, there was no discussion about automatically spurring a new right, and vice versa. And so there was a lot of panic and uncertainty about, whether that right would automatically transfer. And so there was absolutely an increase of filings of trademarks and registered designs. That said, and it seems like that will end up, being okay in the end. Who knows how it'll shake out in the next couple of months and years, but at least right now, those rights will seamlessly transfer, even if you don't have the corresponding UK registration or application. But on the patent front, not necessarily, not yet. Patent strategy, because of the Patent Cooperation Treaty and the European Union, the way that structure exists right now, there hasn't really been much change as far as we can tell.
Okay.
And your recommendations?
Yeah, so as I mentioned, and you're hearing today, just this idea of being proactive. Again, even though we don't have a final resolution on what Brexit might mean and all of the details, in particular agreements and looking at your existing IP portfolio from a trademark and patent standpoint, and then understanding, will these rights convert? If they don't, should we be taking other measures to protect ourselves in the form of some other IP filing? And again, considering if your rights will be sustained in both the EU and UK, and do you want them to be? And then, thinking about updating your overall strategy with respect to the Hague Agreement or the Madrid Protocol, or the patent filing mechanisms as well. Enforcement strategy. So again, this really goes back to finding the appropriate jurisdiction that you want to try to enforce your IP rights in, and where the best place to do that is. And then, finally, the agreements aspect, which really impacts every business. And really looking at, will our current agreements be sufficient, or do we have to renegotiate them, re-sign them to avoid uncertainty? And then, it's sort of funny to think about any new agreements and using updated terminology, which the terminology we use today could be very different tomorrow. So that's a moving target, unfortunately. But, I think it's sort of best practice to really, stay on top of it and make sure you're consistent with the current terminology that's being used.
And that really gets us to our next to last topic, legal contracts, terms and conditions. Nicole, you touched upon it, that this is something that you need to go back and revisit. When you say EU law will apply, does that mean 20 years from now, when there's a dispute and this is in the UK, you have to be in a UK court but apply EU law? There's going to be a lot. So Aidan, you've got some perspective on what's done, now in general, and where sort of the landmines could be.
Yeah, well, I suppose at the moment, if you've got a contract, say out of the UK, the final jurisdiction, if you like, ends up in the ECJ. Post-Brexit, that won't be the case. It'll be the Supreme Court in the UK will be the final arbiter if there is a dispute. As Nicole said, most contracts will have some sort of territoriality built into them. So all contracts will need to be reviewed to see whether or not it's just UK or it's the European Union in general. If it is the European Union in general, I think those contracts are going to have to be looked at carefully, probably to have a UK contract and a non-UK contract. Most of the EU is civil law as against common law. The only two jurisdictions that are common law are Ireland and UK. So a lot of companies are looking at papering, if you like, their EU contracts in Ireland as against anywhere else, so that they can stay in common law as against having to go to civil law. So I think, again, it's a bit like the supply chain. It's a bit like the intellectual property piece. You really need to look at what do you have in place and work out whether it will be fit for purpose post-Brexit, on the basis that the UK, hard Brexit, soft Brexit, as Prime Minister May said, Brexit is Brexit. They are going to be a third country, and therefore all the paper needs to reflect that. I would have thought that having a UK contract, making that enforceable in the EU might be difficult, and therefore that sort of split contract or dual contract approach is probably, where most companies will go. I'm going to say publicly, I am not a lawyer, and therefore this piece is something that I'm not particularly comfortable with. But just common sense would dictate that if you've got a contract that's currently in place where the jurisdiction is the ECJ effectively, and once that changes, it'll be the UK court suing on that contract somewhere in Europe could be different.
And again, something to be proactive about, as opposed to
Correct.
leave it to the interpretation of the court. So I want to make sure we have enough time for the case study and talk about solutions. I don't want to spend all of our time talking about problems without offering up a piece, ending on a piece of good news. So data privacy, I think we've touched on most of the issues there. So
the take home there is, if you have some sort of UK subsidiary and haven't heard anything about the GDPR, please email us immediately, because this is a very large privacy regulation that is now currently in effect with some pretty severe penalties, and really dictates how businesses are interacting with individuals. And this applies to any business inside and outside of the European Union. So certainly applies to a lot of U.S. businesses who interact with any individual in the European Union. So really sweeping regulation that impacts millions and millions of individuals and businesses. So if you have specific questions, please contact us. Hopefully you've been implementing all of the, updated policies, including opt-in related provisions, specific opt-in, which is really probably the most acute thing for businesses right now, because in the U.S. especially, we have a pretty strong policy of people giving us their email address, and then we will promptly send them messages, marketing and email and otherwise, pretty frequently. And so now there is an affirmative duty to contact individuals to opt in. And so this has a huge implication for many businesses that operate both in the U.S. and in Europe, especially if you're collecting information from individuals in Europe. So if you're still using your old mailing list, again, maybe think about ways you can affirmatively get consent from the individuals on that list as well.
Great. And then again, currency and debt considerations. We saw a lot of movement in currency values. I think we've discussed a lot of these in sort of the things to keep in mind: the tariff rates, the weakening pound to the euro. Companies that have debt in both euro and sterling. Just a lot of complexity is going to arise for treasury management.
Yeah, I think there are about 15 currencies within the European Union, so it's not that there's just sterling and the euro. Many countries haven't joined the euro; they maintain their own currency. So trading in Europe, you do need a treasury policy, and there's simple things you can do in terms of if your customers are in sterling, and your some of your suppliers are in sterling, use the same currency, like rather than converting everything back to euro or back to dollar, and it's just a case of being proactive about the management of your treasury function. I think a lot of companies just don't really have a treasury function. They just get back into their home currency, wherever that is, and then have to convert back out the other way.
Right.
So the Brexit really hasn't had a major issue there, other than perhaps the tariffs when they come in.
One other thing to think about, sure. And so finishing up the list of issues to think about with Brexit coming down the pipeline is really what seemed to drive Brexit is the people issues. So Aidan, if you can sort of give us a little perspective on as we mentioned, there's going to be no more free movement of people between the EU and the UK. There is the treaty between Ireland and the UK for free movement. So I think it provides some opportunities.
I mean, I think this is a really interesting one because, we would have a lot of UK clients and they're scratching their head and they're sort of saying, who are we going to get to work for us? Because particularly the lower paid jobs tend to be done from the European Union citizens who've come from, say, Eastern Europe, where the standard of living would be a lot less, particularly in areas around, say, food production. Food production is largely driven, not maybe dissimilar to, some of the scenario you have here in the United States down towards the border with Mexico. It's okay to have a policy like that, but the practical implications for the UK are going to be, far-reaching. The treaty you refer to is a treaty called the Common Travel Area. I think it was 1929 it was put in place, which basically allows an Irish person to go and work and live in the UK with no visa requirements and vice versa. So in the context of solutions and, potential solutions for companies is to bifurcate their business in the European Union into a UK piece and a non-UK piece, having the EU piece in Ireland, because it will allow the UK workers to, come and go quite freely. Whereas if they're based in other places in Europe, I'm assuming that post-Brexit there's going to be some sort of visa requirement or some sort of restrictions on the ability of people to work in that other country, which would be exactly the same as, say, someone from the United States coming to live and work in Ireland. There's a process you need to go through. And processes, as we know, cost money. They put the time delays in place. So, there's a business cost to this. Whereas if you had an Ireland-UK solution, potentially a lot of those costs wouldn't exist.
And so now that we've gone through all the things to think about, there are some solutions out there. Again, the purpose of this, one of our objectives is to make sure that we've deposited in people's minds, and we've been trying to do so with our clients, is if you do have this scenario that part of your business is going to be disrupted because of Brexit, as Aidan alluded to, this treaty between the UK and Ireland on the free movement of people provides a great opportunity that other European countries don't necessarily have. So, you've worked on a number of these, Aidan, and just want to get a perspective on what has happened, what do you see out there, and what should people be thinking about if and when the complexities of Brexit start to hit the U.S. press on the front page.
Sure. I suppose the starting point is to look at the business on a case-by-case basis. Ireland does provide a lot of solutions, but not necessarily the best solution the whole time. So it's a case of looking at the case that you have in front of you and working out, a number of factors. A lot of technology companies work really well in Ireland because the product tends to be delivered, via the cloud, or it's not been sold in a shop, if you like. It's been sold over the internet, and those technology companies base themselves in Ireland for a number of reasons, and we can talk to those later. But what we've done with a number of clients is that have been based in the UK alone. We've basically split the business into the UK piece and the non-UK piece. The non-UK piece being giving it access to the rest of the European Union. Now, these companies are being proactive. I'm not necessarily suggesting that companies do this because we don't know what the answer will be. So, I can't put my hand on my heart and say you need to do this because otherwise you won't be able to operate. We don't know if that's the case. But these companies, because of the relative low cost of it and because of the sector type that they're in, and these companies typically are either in financial services or fintech, as they would call themselves, so technology companies in financial services, they've taken the decision to go now rather than potentially be in a situation where there is a hard Brexit and the UK government either try to stop a flight of capital, making it very hard for them to get out, or alternatively, there's a period where they can't actually provide their goods and services to the European Union because of regulatory issues. So they've literally just split the business, split the functions, and as I said, we worked on a number of these. And again, the starting point was to work out why would Ireland work in those particular circumstances. That came down to the availability of talent, because even though there's only 4.5 million of us in Ireland, there's probably more actually here, but because there's 4.5 million people, the actual workforce is 500 million people, because again, we can bring people in from all over the European Union. There is a huge influx of non-Irish people into Ireland, and they're very welcome. We don't have a lot of the issues perhaps that other jurisdictions have, and it's a very diverse, multicultural society, and those tech companies base themselves in Dublin and the surrounding counties around Dublin. And because of the nature of their business, it doesn't matter. They can be literally anywhere in the world. They can just deliver product. Our tax rates are very attractive. Our core tax rate is 12.5%. But for technology companies, there is a special tax regime which has a tax rate of half the normal rate, so that's 6.25%. And that's OECD approved. And meets all the requirements of the post-BEPS era. So those companies are, I suppose, protecting themselves against the worst-case scenario. If, as I've already said, if I was asked to put my hand on my heart and say, do you need to do this? I couldn't say that because we literally do not know what the outcome is going to be. But the relative costs involved are not major. And Ireland has a track record, I suppose, of tech companies in particular being able to deliver. So I think that's why they tend to pick Ireland.
Absolutely, and in talking to some of our clients, it's the existence of common law also becomes a very, very forceful benefit of when you're moving in. We had a client who was looking at another EU country. They did have a higher effective tax rate. It was civil law, not common law. And when we put this chart together for the client, comparing and contrasting, his only comment was, "Wow, I'm really happy I talked to you guys," because he had not thought through any of that. So it's again, I think it's the purpose of this webinar today was to give people things to think about. Brexit is, at least from a U.S. perspective, the financial institutions have addressed this just because they don't want a disruption. I think a lot of middle market privately held companies maybe are watching this, but are trying to figure out what to do. To be proactive, you're guessing. You may guess right, you may guess wrong, but being proactive means you're not going to get caught flat-footed. Where if there is a hard Brexit or some rough transition period where you can't move capital, you can't make this movement, you're not trapped for that short period of time. And again, we're all looking through the crystal ball. So, I think we had in our waning moments a little bit of a case study that'll I think is pretty typical of, Nicole, I think what you and I see on a regular basis. Nicole, why don't you walk us through the case study?
Yeah, so we wanted to try to tie everything together in terms of, all of the scary problems we've brought up and the uncertainty, and then some of the potential solutions, that might be relevant to, people attending the webinar and here in person. So, the idea would we'd have a company, Data Tech, based headquartered in Delaware, a Delaware corporation headquartered in Chicago, a number of years ago formed a UK subsidiary, which has a facility outside of London. In addition, the UK subsidiary developed its own technology, is operating in both the UK and throughout the EU. Very commonly for a lot of the clients, employees, both in the UK and other jurisdictions like France and Germany, some of those employees might be working from a home office or, otherwise. And then the UK and German employees prepare data analytics services for customers located throughout the EU. And then the team in France providing technological support and development for new technologies. And so, Data Tech is coming to us for advice after attending this seminar, saying, why have you scared us so much and what do we need to be doing? So with that, I'll turn it over to the group to discuss. And I think, from my standpoint, the IP part of it, again, really is, based on what we talked about. But one specific thing for anybody that has employees in Germany specifically, there are very unique laws in Germany that requires every company to pay their inventors. And it is a very, very complex law that any business that operates outside of Germany does not understand. But so from this particular scenario, and not unheard of to have German employees, very specific law that you must pay inventors, and if you are not, that is directly, contrary to German law. And it's about a 10-page document that frequently is circulated that has all kinds of provisions in terms of the current royalty that you must pay. And that royalty continues after the employee is no longer employed, by the way. And it's normally calculated based on sales and all kinds of very complex calculations that universally businesses do not like. So just be aware, besides the earlier comments about agreements and, IP enforcement and registration, there is a unique piece with respect to having German employees specifically.
That's true. And I think it's, given this case study, from a high level, it's okay, the UK becomes a third country. So now you have to put on your crossing a border hat and say, okay, I now have a UK company with employees outside the quote-unquote country. what does that mean? What do I need? What agreements do I need in place? What withholding and tariffs and other costs may come into play? What visa issues do I need to worry about if I'm bringing them back and forth, for training to work part time in our UK headquarters? From a data analytics services, maybe they have data privacy. We've talked about the issues there, but I think again going back to let's sort of roll this case study back. And your data tech located in Chicago, it's 2018, and you're thinking about opening up that UK subsidiary. And I think, Aidan, it gets back to your structure is the UK part of the answer? Do you need to also go with this dual headquarters approach? Why, is Ireland the right country? Is another EU country the right country? And walking through that. So I know you've been through it in the fintech area. I think it's going to be, going forward, it's going to be part of things that we do on a normal basis. So, let's do a country analysis. We've decided we like common law instead of civil law. We're not compelled to be in Germany, France, or Spain. Should we look, are we in UK or Ireland? And I think that brings out the whole, EU versus non-EU analysis.
Yeah. Post-Brexit, the United Kingdom will still be a massive economy. It'll still be fifth or sixth in the world. So it's not going anywhere. It's still going to be a very important place for US companies to be getting into. I think how they get in to the UK market and the European market will change. And I think it effectively will be sort of this dual approach, a foot in both camps. And I suppose it's a case of the type of business and where the bigger footprint would necessarily be. Obviously, the UK financial services industry is absolutely massive. I think it makes up about 70% of the UK economy at this stage. It's some very, very large figure. And obviously, they're not only selling to the UK, they're selling to the whole of the European Union, which is the biggest single market in the world. And I think Michel Barnier recently made a comment that really caused shockwaves in the City of London, because he said, we don't need the City of London. So the EU are very conscious about regulation, and they will not want a major player located in the European Union or geographically, but not under the control of the European Union and the ECJ. Back to the point, I think the UK is going to continue to be a very important market, and US companies seeking access to it and the European Union will have to just change slightly and have this dual approach, which is what we're doing for clients who are proactively looking for that. In terms of Ireland, just very briefly, people come to Ireland for a number of reasons. Talent is one. As I've already mentioned, the talent pool is 500 million people. And that's going to remain at 500 million people even when the UK leaves because of our common travel area. Secondly, there's the tax considerations, and even post-Trump tax reform, Ireland still provides a good tax solution. Interestingly, in sort of a bit of a quirk, there's actually a tax cost to being in a jurisdiction with a higher tax rate than 13 point, I think it's 1.25. So Ireland has actually come out of the Trump tax reform quite well. I doubt if it was a strategy on behalf of the president, but I think it's probably just an unforeseen consequence of the
process.
Yeah. Another reason why people look to Ireland as against the likes of France or the Netherlands is because of our employment laws. Our employment laws are probably as close to your laws as anywhere else in Europe. So we don't have fire at will, which you guys have here, after 12 months. But for the first 12 months, you have fire at will. And I would always say to a client, if after 12 months you don't know if they're the right person or not, it's probably more a reflection on the company than the employee. It's not that they're anti-labour, but they're actually quite pro-business. I think the mix is right. And then there's track record, and track record is really, really important. If you're setting up in a new jurisdiction, you really want to know that other companies have done it before. So the amount of companies that have, hit the European Union through Ireland and successfully done so is a major reason why companies do it. The talent pool that's there, most of the people who are hired for clients that we bring in from the States, they've been there, they've done it already, they've done it for another company, So that track record is really, really important as well. And the last piece is education. The education system in Ireland is very geared towards assisting businesses setting up in Ireland. So we have a client who was brought in. They have a very specific need around technology, software development. And the technology college in the town they went into designed the course to specifically suit that company. So that sort of cooperation between education and business, again, is a major driver.
Great. And just in a closing note, I think Nicole chime in, but from a U.S. perspective, in trying to work overseas, it's putting together the right multinational team. And I know you've worked with a number of firms in the EU and in Ireland, as have I. And each firm will have a different approach, different strengths and talents, and the ability. I've found in working with a firm that I've worked with on several deals, it's easier to bring that ongoing deal to them because where the task list is going to fall. So again, U.S. companies that are struggling with these issues, the role for U.S. counsel, the role for Quarles and Brady is that to make sure you're just not going in blindly, pulling out the yellow pages and finding under the attorneys under found one, and same with the tax advisors. Aidan and I have done a few things together where. It's to know that sort of trusted partner role really helps solve a lot of the issues as opposed to, trying to just, talk past each other. So it's somewhat of an art form on doing these. And I think with Brexit causing us to rethink the UK, there's going to be more and more middle market privately held companies looking at Ireland and elsewhere in the EU. So our panelists, I just want to say thank you. We've made it through the full 90 minutes, so everyone gets their full credit of continuing legal education, which is very important. So I appreciate Aidan. Thanks for stopping on your way back to Ireland, a short stop in Chicago. And Matt and Nicole, thank you.
Thank you for having us.
So that concludes our program, and thank you very much.
Thank you.